parentage in the other. Then same sort of process. There could be artificial insemination. Typically those donors are anonymous. There's lots of sperm banks. There's lots of donor banks that you could make a selection about who you wanted to be the biological father of the child. You have to, there are some consents that the woman would do about the entry of the sperm into her body for purpose of achieving pregnancy. But let's say that happens and she delivers a child. The code does not set forth a specific protocol for how a same-sex partner is going to adopt the child of your partner. But there are 2 counties in Texas that are routinely doing this: Bexar County in San Antonio, Dallas County. And the 2, basically we have just developed a protocol for granting those adoptions. And they take the form of a step-parent adoption, where basically you do a home study on the couple, you file health and genetic information on the child, the adopting parent gets criminal clearance, and then you file the adoption, and the adoption is granted. There is one case in Texas that, well, there's a couple, there's 3 or 4 cases in Texas. There's one case that sort of is the case, and it's a case where I'll say parent number 1, this is a couple residing in Galveston. Parent number 1 goes to Kazakhstan, adopts a child in Kazakhstan, brings the child back. Then the couple residing in Galveston County, they go to San Antonio. They get a second parent adoption. So now you've got one parent who has parentage achieved by adoption in Kazakhstan, one parent who has parentage achieved by adoption in San Antonio. So that couple is together for a period of time, and then they separate. In Texas, an adoption cannot be challenged or collaterally attacked for any reason 6 months after entry. So these women separated more than 6 months after the date of the second San Antonio adoption, and the mother who adopted in Kazakhstan tried to allege that that adoption in San Antonio was void, basically because there was not statutory authority in the Texas Family Code for granting the adoption, and the Court of Appeals in Houston First District said, you've waived it. And that primarily that you're attempting to collaterally attack an adoption that's more than 6 months old. We have 3 cases in Texas that kind of follow that line of thinking. We have not had a case where someone has challenged by collateral attack or direct attack an adoption that was granted within 6 months. So there may be something to be said about that when that, if and when that happens.
That's a lot of information for me. Ms. O'Neill, your forte is handling child support and custody issues for LGBT clients at both the trial and the appellate levels. So what is the current law in Texas for non-parent, or what we would call emotional parents?
Okay, can you?
Sure.
And I have copies of my flow chart down here. I didn't know what's in. So in the starting analysis of what happens when a gay or lesbian couple breaks up and one of them has a child. So the first point is you have to think about what is the legal definition of a parent. So are y'all in Justice Thomas's family law, or?
How many of you guys are in Justice Thomas's class? How many of you are in Professor Weaver's class?
Okay. So have y'all studied what is the legal definition of a parent? No?
We have.
All right. So the legal definition of a parent in the Family Code says that a parent is the mother, the biological mother, a man presumed to be the father, probably because of marriage, a man legally determined to be the father, a man who has acknowledged paternity, or an adoptive mother or father. Now, kind of going to David's area here, the definition of a parent might be a biological mother and an adoptive mother, right? So that's where some of us who do the adoptions kind of get to in doing same-sex adoptions and getting the legal authority, is that the definition of a parent includes adoptive parents. So if you have a person who thinks of themselves as a parent, who the child thinks of as a parent, but who does not meet that legal definition. That would be what in legal terms we would call a non-parent, or being respectful to that person, I call an emotional parent. So when you have an emotional parent who is seeking access to a child, you have a specific analysis that you have to do, and they're very difficult. So have y'all had CivPro, maybe? Do you know what standing is? Somebody know what standing is? Okay. So the first question, whenever I explain it to clients, I tell them the first question is who gets to enter the door of the courthouse? And then who gets to stay in the courthouse, right? So the first question is, how does a non-parent get standing to sue for access or rights to a child? And that comes from the Family Code standing sections, and generally the one we use is whether that parent has had actual care, control, and possession of the child for 6 months, ending not less than 90 days prior to filing suit. Now, there's a lot of legal wrangling that goes into that short little phrase. What does actual care mean? What does actual control mean? And what does actual possession mean? There's been a lot of cases litigating about what happens if the care, control, and possession occurs during the relationship. What happens if the relationship breaks up, but the two people continue to share custody, so to speak, not in a legal sense, but in a factual sense, share time with the child, kind of like a divorcing hetero couple might do? Does that rise to the level of actual possession, or does it have to be continuous? What does actual control mean? Does that mean that the non-parent has acted like a parent? Does that mean that it's happened without or with the consent of the biological parent? And if the biological parent is consenting to the non-parent acting like a parent, for example, taking the child to the doctor, then isn't the parent really controlling? How does a non-parent actually exercise control independent of a parent if the parent is the one consenting? Isn't that really the parent keeping control? And so then you have the timing requirements. So if you've got more than 90 days that expires between the last time the non-parent has seen the child, that person has a problem. And that kind of gets back to the question of if they break up and have kind of a split custody type arrangement and 90 days goes by, is that sufficient under the statute for standing? Those are all questions that are being heavily litigated in Texas law right now. I had one of the cases on point, which is MKSB, and there, I think at one point in time, within a year of MKSB coming out, there were, I think, 9 or 10 cases pending in the courts of appeals across the state litigating these same issues. And I'm sure since I haven't kept count lately, there's been a whole lot more. Unfortunately, the Texas Supreme Court has not seen fit to take up these issues for us and give us some clarity.
And I've got one question on
Yep.
that. How does the court have any discretion over that 90 days at all? Is it just,
No.
okay?
There is no discretion over the
parent
timing.
or anything?
There's discretion over the lawyer's ability to argue whatever your situation was might fall within the 90 days.
Okay.
For example, an every other weekend type split of time with the child, whether that falls within possession within 90 days. But there is no discretion in the 90-day rule. So if you can prove that you have standing under this section of the Family Code, then you can keep going in your lawsuit. If you fail in proving standing, then you're kicked out the door of the courthouse and the courthouse doors are closed to you. So the next step in the question then becomes, if you have standing, what next? How many of you have studied the case of Troxel v. Granville? Nobody. Really? Have you ever heard of it? Well, Keith and I